the law is a jealous mistress. I always construed that to mean that law is a very demanding task and vocation. However, you could also say that the law can be cruel. It can be a cruel mistress. And I recently became aware of a case involving bullying in Massachusetts. And the plaintiff, the parent suing on behalf of a severely injured child, were not allowed to recover. What happened was, in the City of Lynn and in its school system, a fourth grader who arguably had been subjected to a lot of bullying was lining up in front of school one day to go in, and unfortunately another boy knocked the first boy down the stairs, and that person, that child, suffered a severe spinal injury, and it resulted in paraplegia. So the child's parents brought suit against the child who pushed the injured child, and also brought suit against the City of Lynn. I choose in this blog to confine myself to the claim against the City of Lynn. Now, we've talked about the Mass Tort Claims Act in past blogs, and what that is it changed the law in Massachusetts beginning in 1977. It allowed you to sue the sovereign, the government, or any political subdivision, including a municipality of the government. School systems come in under that. The problem with that statute is that it affords a recovery of no more than $100,000. So it can be rather minimal in relative to the injury sustained. But let's talk about the theoretical nature of the claim. What about the claim against the City of Lynn for not policing or seeing to it that bullying didn't occur in that fourth grade classroom, or when kids would line up to go into the fourth grade classroom? Is the City of Lynn liable, that is, civilly responsible for what happened? And the law says, yes, we permit you to sue the sovereign, the government, or the school department, but we only permit you to sue it up to $100,000, but you cannot get a recovery in this instance. Why? Because the law says that public employers, such as the City of Lynn, are responsible only for affirmative acts that they do, not for a failure to do something, not for ordinary negligence as we understand it. And they say that there have to be reasonable limits to the government's liability. And therefore, because this act was a violent or tortious act of a third person, and the school simply, if you will, failed to stop it from happening, that's not the kind of claim that you can make out under the statute. It's very unfortunate that this result did occur. It's very unfortunate that recovery couldn't be had. And the court doesn't want it to be understood that they don't care about bullying. Indeed, the first part of the decision and the last part of the decision dealt with the evils of bullying, and we all understand that. But the court said there is no civil liability against the City of Lynn and its school department. Thank you.